where I grew up.
Called to order. After 8 years of saying the House State Government Committee, it's always a task to remember what I'm supposed to say and not be in that robotic mode. So, Pam, do you want to call the attendance? Here.
Representative Causer. Representative Rush.
Here.
Representative Fritz.
Here.
Representative James. Representative McKenzie. Representative Metzger. Representative Neal. Representative Orson-Powell. Representative Kyle. Representative Rapp. Representative Shank.
Sorry.
Representative Schindler.
Snyder and Sable leave. Okay.
Representative Vitale.
Here.
Representative Comida. Here. Representative Daly. Representative Fiedler.
Here.
Representative Isaacson. Here. Representative Kruger. Representative Otten. Representative Snyder.
Leave.
Representative Warren.
Here.
Representative Zabel.
Leave.
Thank you, Pam. We do have leaves for Causer, Schemmel, and Warner from the Republican side also. Before we get started, if I could ask everyone to please rise, and Representative Dush, would you lead us in the pledge, please?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Representative Dush. Representative Miles also joined us. Representative Miles, if you'd like to join the committee, there's plenty of seats up here. You'd be welcome to sit with the committee if you'd like. And this morning's informational meeting is related to the Delaware River Basin Commission and some issues that are of concern and within that area under that commission's intervention. And Representative Fritz's district has been impacted in a significant way, and Representative Fritz and I had worked on the issue a little bit last session, the House State Government Committee, and we have this informational meeting this morning. We have some legislation that the representative has also introduced that we'll be entertaining in the near future. So wanted to give Representative Fritz a moment to say a few opening remarks before we invite our first presenter to talk with us this morning. Representative Fritz.
Thank you, Mr. Chairman. I truly appreciate the opportunity. Friends, I'm honored to represent the 111th Legislative District. Those residents, my constituents, are hardworking, salt of the earth, and tax-paying residents. But some of those in my district, those residing in Wayne County, are being wronged. These good people are undeservingly being robbed, stripped of their property rights. The perpetrator is a quasi-government agency with no accountability that, and we will illustrate this today, that has an insatiable appetite for power, authority, and control. Added to that dangerous reality is the fact that they have been infiltrated by ideologically fueled activists. This agency, frankly, has gone rogue, untethered from objectivity, fairness, and non-bias. The agency that I'm referring to is the Delaware River Basin Commission, or commonly referred to as the DRBC. The DRBC has rendered my constituents second-class citizens. The theme at hand is one of unfairness, discrimination, and injustice. Ben Franklin was quoted as saying, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." And those very words are chiseled into the granite steps leading to this Capitol. Our founders took action to reject tyranny. Let us not be blind to the fact that that very cause is still upon us. Sincere thanks to our testifiers today, and thank you again, Mr. Chairman.
Thank you, Representative Fritz. Our first presenter this morning is Mr. Thomas J. Shepstone. He's the principal with Shepstone Management Company. Welcome, sir, and you can begin
Thank you very much.
presentation when ready, and we'll have some time for some Q&A with you. Thank you.
Thank you. My name is Tom Shepstone, and I'm a professional planner from northeastern Pennsylvania. I have over 40 years of experience working with communities throughout the Commonwealth. I also represent numerous private clients, including some in the natural gas industry. I want to be clear about that. And I publish a blog advocating for natural gas development in our region. Finally, I'm a landowner with a natural gas lease that has been in limbo for nearly a decade. I'm here today to speak about the Delaware River Basin Commission Eminent Domain Activity Act, which I support. It's simply a matter of justice, equal justice under the law. Those are the words emblazoned on the front of our U.S. Supreme Court. And Pennsylvania's response to the political theft of DRBC region landowner rights will test its commitment to this most fundamental of all constitutional protections afforded us as Americans. The bill before you for consideration, HB 827, advanced by my good friend and state representative Jonathan Fritz, is the proper response to this outrageous theft. It is to put the burden of the theft on those who are perpetrating it. The bill does so by calling out the crime, the usurpation of rights enjoyed by landowners in the Susquehanna River Basin Commission and everywhere else in the Commonwealth to the Delaware River Basin landowners. It is also prescribed the penalty, reimbursement for what has been stolen. The DRBC, which is run by the same governing majority members as the SRBC, is picking economic winners and losers in Pennsylvania based on political ideology, allowing natural gas development in the SRBC and denying it in the DRBC. This is despite the fact the DRBC majority has the evidence in hand from ongoing, continuous water quality studies by the SRBC showing there's been no discernible impact on the quality of water resources on the Susquehanna side. That's not equal justice under the law. The DRBC somehow, based on what can only be described as a reading of the entrails, claims superior authority to protect water quality from purely speculated risks. They propose to use it to ban an otherwise legal activity, despite overwhelming evidence to the contrary from the SRBC. More importantly, they ignore the water quality standards already applied in both basins under the Clean Water Act and the Clean Streams Law, standards any water must meet without discrimination. The natural gas industry is able to meet the very highest of these standards. That, of course, is why the DRBC seeks to now throw those standards to the wind and impose a ban, being imposed on no other industry or land use. That's not equal justice under the law. The DRBC proposes a ban on natural gas development. Those who own nothing but natural gas rights will lose 100% of what they own, and there are many people of that sort. Those property owners, who I might add possess the dominant legal estate under Pennsylvania law, will have cause to file takings claims. They will, though, have lost all they own and may well not have the funds or the endurance for the lawsuits necessary to get back what is rightfully theirs. That's not equal justice under the law, not when government can steal what is yours and force you to spend your estate on legal fees to get it back. It's theft. It's also theft for those who own both land and natural gas rights. Why? Because regulating away those rights to leave landowners only with the residual value of the land for other uses must be based on some evidence of an actual case for additional regulation. Read the DRBC justification. I encourage you to do that. Singling out one county in Pennsylvania, one county out of 67 in Pennsylvania, to disallow natural gas development. We are the only county in Pennsylvania, Wayne County, that has natural gas resources that can't develop them. You'll be shocked at how shallow and speculative that piece of trash is. Your drinking water today in Harrisburg, I don't see any up here on the dais, but if we had water, it would be water that came from the Susquehanna River and it's then treated. That's how Harrisburg gets its water. That's from the Susquehanna River Basin Commission, where we have a decade of experience with fracking. And no one seriously worries about drinking it. Yet the DRBC would have us believe Philadelphians and New Yorkers are somehow subject to unique risks based on nothing but mindless speculation. Meanwhile, there have been fires at chemical plants on the Delaware that have resulted in spills directly into the river. There have been overfeeds of chemicals into drinking water at treatment plants along the Delaware. There have been barge accidents that have dumped acetone into the river. There have been truck accidents and all kinds of other accidents that represent real risk. Are we to ban these things as well? Based on the mere speculation they could happen again? No, of course not. Only in the case of fracking does the DRBC insist a ban alone will do. That's not equal justice under the law. The DRBC also proposes regulation on the exporting of fresh water to other basins for natural gas development that are stricter than exports of water for other purposes. Think about that for a moment. If freshwater exports need to be governed, then why in the world wouldn't the same rule apply to all? It's patently clear from this the DRBC is acting ideologically and politically, not scientifically or in accord with its compact. That's not equal justice under the law. There's also no equal justice when it comes to process. The DRBC has stacked almost all of its committees with representatives of the Delaware River Keeper, a special interest anti-gas advocacy group that sued it over gas drilling issues. It has, too, actually taken money from the same William Penn Foundation that funds the River Keeper. Worse, the DRBC used the money to supposedly study gas issues and provide an excuse not to act on gas drilling regulations sitting on the shelf since 2011. Talk about corruption. The DRBC state members have also engaged in a completely sham public hearing process with respect to the proposed fracking ban, with all four governors proudly and stupidly announcing how they'll vote before the hearings even began. Where is the equal justice under law in such sham hearings? The DRBC, in other words, is an out-of-control agency. It's on a slippery slope of ideological opposition to natural gas designed to appease special interest. All law, all rights, all justice have been sacrificed along with our property values. The DRBC is also assuming your police powers as legislators, deciding it has the power to control even land use within your jurisdiction. It is leaving you and us in the dust as it pulls more and more power to itself, pulls it into their office building in West Trenton, where, ironically, they keep it warm in the winter with a newly installed gas heating system. So think about that hypocrisy. You can and must reassert your own authority, the authority to establish standards for natural gas development in all of Pennsylvania, not just outside the DRBC region. Those standards can and are being met across Pennsylvania in sub-watersheds already classified as exceptional value and subject to the highest threshold criteria. If the DRBC supposes it needs even higher standards, let them develop them and apply them equally to all industries. That's equal justice. HB 827 is one way to stand up to these bullies. I encourage you to support it. Do not be dissuaded by disingenuous arguments claiming the DRBC has extraordinary rights that exceed even yours, when you, together with others, are the very source of its power. Do not be distracted either by the suggestion that the SRBC's continuous water quality monitoring program somehow doesn't matter compared to the incessant speculation of obscure risks by serial protesters. These people are paid by the William Penn Foundation to destroy the gas industry that has done so much for Pennsylvania, an industry doing more to reduce CO2 emissions than anyone or anything else in the world. No, do not be distracted by the Delaware Riverkeeper's phony talking points. Look instead at what the DRBC members say when they're wearing their SRBC hats. There's no discernible impact on water quality. And if that's not good enough, take the word of a Penn State study of Bradford County groundwater last year that found, and I quote, groundwater had either improved or remained level from samples taken prior to the 1990s, and groundwater chemistry in one of the areas most heavily developed for shale gas, an area with 1,400 new gas wells, does not appear to be getting worse with time and may even be getting better. It's time someone put the priority on these facts, rejected the falsehoods and reckless speculation of protest groups. It's time DRBC landowners are no longer treated as second-class citizens. It's time for equal justice under the law. Thank you very much.
Thank you, sir. Committee members with any questions? And just to remind everybody as we move forward through this and other meetings, when we have hearings, we have informational meetings, and we invite guests here, they are our guests and to be treated as such. So when we're asking questions, we want to ask questions. We don't want pontification and remarks. This isn't time for your remarks. Your remarks can be made at a voting meeting. It's a time to use the time wisely with our guests because other members may have questions. So questions for the member, for the presenter. But if it's time you just want to make remarks, this isn't the time. Representative Dush.
Thank you, Chairman. Tom,
Yes.
you mentioned the SRBC's 2016 report. Has there been a response from the DRBC to that?
I'm so glad you asked that question. They do not mention it. Can you imagine that? They wrote a justification for a fracking ban, and they did not mention, not one iota, not one word, about a report in their hands when they're wearing their SRBC hat about continuous water quality over a decade that has proved no impact. They did not mention it. That tells you everything you need to know.
And to get to the root of actually what this bill does, is it not true that those gas rights, those from the time of William Penn, they've successively been sold off or transferred by inheritance, that sort of thing. So those gas and minerals that are below the surface, they actually belong to the people who own those mineral rights.
Correct.
The Commonwealth has given up rights to the gas. So to make a claim that somehow the Commonwealth owns that is a falsehood. Is that correct?
I agree with you 100%. And I would note, I have some distant relatives. I'm not close with them, but I know them. And they were among the parties that sold tens of thousands of acres to the state for state game lands and things of that sort, and they retained the mineral rights. Now,
Thank you.
that's the point, you know. So,
Thank you, Representative Dush. Representative Vitale.
Thank you, Mr. Chairman. You know, Mr. Shepstone, I've listened to your comments. I've never interacted with you before, but after hearing you for 10 minutes, I just must say your comments are outrageous, irresponsible, and border on defamation. I personally know the Delaware River Keeper, and for you to suggest that her representatives are on the Delaware River Basin Commission is just patently false. And to suggest that group is paid for by the William Penn Foundation to destroy the gas industry. People, I know who the volunteers are, I know who the workers are, patently false. And for you to use the word crime in a situation like this and the word corruption, totally irresponsible. I do note from your blog, you're a climate denier, which gives me some indication of your basis in science. I just want to say that for the record, I just am outraged by your testimony.
well, you're incorrect. First of all, for the record, my blog, I think yesterday, put up a post by the energy builders, union members, who, in fact, appealed for support for pipelines because we reduced CO2. And so please don't put that label on me casually as you did. Secondly, the DRBC has 7 committees, and you know 6 of them have Delaware Riverkeeper representatives on them? That's outrageous. You know how many landowner representatives are there? Almost none. They have totally biased their system ever since Carol Collier became their executive director. And I would also note, in terms of the money, that the William Penn Foundation supplies more than the majority of Delaware Riverkeeper's funding, and has for many years, millions and millions and millions of dollars. And they also fund State Impact PA, they fund the Clean Air Council, they fund Penn Future. They're all funded by the same William Penn Foundation combined with the Heinz endowments.
Thank you, sir. Thank you for joining us today.
Okay, thank you
We
very much.
appreciate it. It's time for our next testifier. It's 10:20. Thank you, Mr. Sheepstone. We appreciate your being with us today. Our next presenter is Mr. Christopher R. Nestor, attorney Overstreet and Nestor, LLC. Thank you, sir, for joining us today. We are ready for you to begin your presentation when ready, sir.
Thank you, Mr. Chairman, members of the committee. My name is Christopher Nestor, and I am with the law firm of Overstreet and Nestor, LLC. Thank you for the opportunity today to discuss the difficulties being encountered by citizens of this Commonwealth seeking to develop natural gas from their private properties, but who have been prevented from doing so by the Delaware River Basin Commission. The Commission, a multi-state, unelected, and unaccountable entity, has determined that it alone has the power to dictate whether and to what extent citizens of this Commonwealth are permitted to develop their private property. I am not one of the thousands of citizens of this Commonwealth whose property rights have been arbitrarily stripped away because they own property in the Delaware River Basin. I do, however, in my capacity as legal counsel, represent citizens who have been harmed by the Commission and are seeking to vindicate their constitutional rights. Because of that representation, I am quite familiar with the deliberate steps the Delaware River Basin Commission has taken to prevent the otherwise lawful, orderly, and environmentally protective development of natural gas in the basin. I'm not here today on behalf of, nor do I speak for a particular client. Rather, I'm here to share my views regarding what the Commission has done to take away private property rights. The Commission, by the 1961 compact that created it, was charged with planning and approving water resource development projects within the Delaware River Basin, such as dams and reservoirs, in order to ensure adequate supply of water in the future. Although the Commission has grown in size, cost, and complexity since 1961, it has, at least historically, confined itself to reviewing and approving what most people would agree are water resource development projects. With the arrival of the shale gas revolution, however, that changed. The Commission, under pressure from anti-development grant-making organizations that fund its operations, decided that all planned human activities in the basin that happen to use water are projects that it has the power to review, approve, or ban from the basin. While the Commission thus far has used this newly discovered power over all planned human activities that use water to punish private property owners seeking to develop their natural gas, make no mistake, shale gas is simply today's target. The Commission's reasoning necessarily extends far beyond shale gas. The Commission, relying on the supremacy clause of the United States Constitution and its asserted authority over all planned human activities that happen to use water, claims that it can preempt this Commonwealth's statutes and regulations addressing, directly or indirectly, the use of water. Because most planned human activities use water, it is difficult to conceive of a land use that is not within the Commission's recently expanded view of its project review authority. The Commission, by a majority vote of the representatives of New York, New Jersey, and Delaware, none of whom answered to Pennsylvania's voters, can displace virtually all of the Commonwealth's environmental regulations and dictate to Pennsylvania citizens whether houses, businesses, farms, factories, schools, and churches can be built, and if so, where and under what conditions. While the Commission's assertion of unlimited jurisdiction over citizens of Pennsylvania is itself disconcerting, the Commission's approach to blocking natural gas development in Pennsylvania is even more insidious. The Commission was quite strategic and calculated. It proceeded in 3 incremental steps to block natural gas development in Pennsylvania, making it difficult and expensive for affected citizens to protect their rights. First, in 2009, the Commission announced that because natural gas wells and well pads use water, they are projects that cannot proceed without the Commission's approval. To underscore its newly asserted jurisdiction, the Commission went so far as to impose a $70,000 civil penalty on a company that constructed a gas well pad without the Commission's prior approval. Second, in 2010, the Commission announced that it would not approve applications for gas wells or well pads until after it adopted rules governing such approvals. Finally, after announcing it would not review applications for gas wells and well pads until after it adopted rules, the Commission took its third and final step. It decided not to adopt rules. The Commission has been sitting on rules governing gas development for nearly 10 years. The Commission, as the United States Court of Appeals for the Third Circuit recently concluded, used this regulatory sleight of hand to impose an indefinite de facto moratorium on natural gas development in the basin. That is, New York, which has its own separate ban on natural gas development, New Jersey, and Delaware have imposed a moratorium that injures only citizens of northeastern Pennsylvania. The Commission's actions have hurt Pennsylvania citizens seeking to safely develop natural gas on their private property in accordance with stringent and comprehensive regulations administered by the Department of Environmental Protection. Leases have been rendered worthless, and natural gas and royalties have been locked in the ground, all as a direct result of the Commission's incremental power grab. Litigation pending in federal court contends that the Commission's power grab is patently illegal. But litigation is an expensive and time-consuming process. This is particularly true when the adversary is a government agency with unlimited funds to spend on lawyers and tactics. Progress has been made, but it is taking time and wasting resources that many of Pennsylvania's hardworking citizens affected by the Commission's power grab do not have. Moreover, the Commission is hard at work on an alternative plan to block natural gas development in the basin. This alternative plan, announced last fall by the Commission and apparently supported by Governor Wolf's administration, is a proposed rule that expressly bans hydraulic fracturing in the basin. The Commission's proposed ban rests on a very shaky legal foundation. But the Commission does not care if the proposed ban, when adopted, is challenged in court. That's because the Commission can spend our tax dollars dragging the issue through the courts for years, all while openly publicizing to its many tax-exempt allies and funders that it is committed to blocking natural gas development in the basin. Finding a legitimate factual justification for an outright ban on hydraulic fracturing in the basin should be an insurmountable obstacle for the Commission. The history of natural gas development in the Susquehanna River Basin and recent studies by the Susquehanna River Basin Commission regarding such development conclusively demonstrate that hydraulic fracturing has been and can be carried out with no measurable impact on water resources or the environment. In addition, a careful review of the Commission's stated justification for the proposed ban on hydraulic fracturing reveals that the Commission wants to ban an otherwise lawful and extensively regulated activity because accidents may happen and spills may occur. This risk, in the Commission's opinion, is enough to justify singling out natural gas development from the thousands of other activities in the basin that pose similar risks. The Commission's moratorium on natural gas and recent determination that it can ban any human activity that poses any risk to the waters of the basin extends the Commission's reach far beyond what was intended by the 1961 Compact. Pennsylvania in 1961 did not intend to cede its sovereign authority to the Commission to the extent the Commission now claims. Nevertheless, the Commission appears committed to forcing Pennsylvania citizens living in the basin who want to make otherwise lawful use of their property and who want to protect their constitutional rights into protracted and costly litigation. Thank you for this opportunity to speak, and I'm happy to answer any questions you may have.
Thank you, sir, for your testimony, for your presentation. Representative Dosh.
Thank you. Pennsylvania's Article 1, Section 1 guarantees the right to acquire and enjoy property. Federal and the other states' constitutions, I believe, in the surrounding or that are part of the Commission have similar rights. I'm just curious, are you considering any kind of a class action lawsuit to possibly have the DRBC disbanded for violating those constitutional rights?
Sir, I'm not here to talk about any particular litigation or any clients I'm representing at this time, although I would suggest to your idea sounds like a wonderful idea.
I think there's an excellent case for it.
People should be looking into that. They should.
Thank you.
Representative Isaacson.
Thank you, Mr. Chairman. My name is Mary Isaacson. I represent the 175th District of the Southern Delaware River, Philadelphia. And to my colleague, I'm the current caretaker of Ben Franklin's seat, and very much am here worried about the constitutional rights about my constituents on the southern end, on the activities that perhaps you're advocating for changes. What about their constitutional rights to the clean water? And I think that's why I'm very supportive of the DRWC and the work they're doing in making sure that the water is protected from things like the rising salt line on the southern end and activities and regulating the water for the drinking area in our region, because the Delaware River is our water source. So while I appreciate the industry's longing to do activities on the northern end of the Delaware River, it affects my constituents and their constitutional rights also. Thank you.
Mr. Nestor, are you able to answer what constitutional rights that folks on the southern end of the river basin would have that would nullify the constitutional property rights of those? I mean, I don't understand the argument as being legitimate. Can you give any legal thought to that?
Mr. Chairman, I believe you have, on one hand, folks who have rights in their property, and as the representative indicated, folks who believe they have rights to clean water under the Pennsylvania Constitution. I don't think you have a situation where you can simply take one group's rights in order to protect somebody else's. We know that natural gas development can be done safely in Pennsylvania. We have stringent and comprehensive environmental regulations to protect the water sources in the state. An outright ban on hydraulic fracturing is simply unjustified when one looks at the information that's been compiled by the Susquehanna River Basin Commission and the extensive oil and gas development that's happened within that basin. We simply do not have the information through those studies by the Susquehanna River Basin Commission that would justify a flat-out ban on hydraulic fracturing, which has been proven to be done safely and effectively. If the DRBC wants to preclude folks from developing their private property rights in northeastern Pennsylvania, then it should pay those individuals for the gas that's being locked in the ground as a result of that ban.
And it was mentioned that the industry wants this. I mean, the folks that you're working with, are they the industry, or are they individual citizens whose private property rights have been taken?
The latter, sir.
Thank you. Representative Fritz.
Thank you, Attorney, for being with us today. Can you shine a little bit of an additional light on how this action or inaction has affected property owners in Wayne County?
Well, property owners have been left in limbo, as Mr. Shepstone has alluded to earlier. They are unable to develop their private property rights, in this particular case, the natural gas that they own and want to develop and sell and obtain a well-justified royalty for that gas. You're locking natural gas resources that are limited in the ground. You are keeping people from enjoying a royalty on their private property rights, all because the commission has precluded them from proceeding and has gone so far to fine people who decide to proceed without their authority.
So people are being barred from realizing that economic opportunity. And with economy in mind, can you give us a dollar value, perhaps, of the royalties that were not realized thanks to the force majeure, or maybe how much the resource underfoot is valued at?
I can't give you exact numbers, Representative. I apologize. Millions and millions and millions of dollars being taken out of the citizens' hands in Pennsylvania.
Okay, thank you.
Representative Vitale.
Yeah, just a couple of thoughts. One, although Delaware River Basin Commission may be unelected, it is appointed by governors who are in fact elected. And on the point of what the will of the people is, I can tell you that my constituents and most people in southeast PA do not want gas drilling in the Delaware River Basin. With regard to the issue of Wayne County, in my discussions with experts in the oil and gas DEP program, tell me there's very little gas in Wayne County anyway. And I've also been informed that in the 8% of Wayne County not controlled by the Delaware River Basin Commission, where this ban would not apply, there's no drilling there anyway, which kind of supports the proposition that we're really not talking about a lot of gas Anyway, with regard to the point that natural gas development will not harm the water, I mean, you can ask the people of Dimick and other areas where there have been these accidents that
Vitaly, do you have a
pollution-
question for the presenter? Because we're going to run out of time for this presenter. We have about another minute.
that
if you have a question
these-
there.
These accidents can and in fact do occur. So thank you.
No question?
It was more of a comment that might invite response as opposed to a
Do you have a response, sir?
questions.
The notion that accidents could happen, Mr. Representative, do you know how many trucks and trailers hauling fuel and other materials cross the Delaware River every day? Do you know how much more of a risk they present to the Delaware River Basin than any single gas well or collection of gas wells that can be developed in the Delaware River Basin? Do you know how many shipping facilities and chemical plants and pharmaceutical manufacturing plants are along the Delaware River Basin or Delaware River and its tributaries that pose much more of a risk than any natural gas well pad ever could? But yet the Delaware River Basin is singling out natural gas for a ban.
Thank you. And I think part of what you'd mentioned in your testimony that should offend every elected official in Pennsylvania is that decisions are being made by representatives from other states that are impacting only our citizens who aren't being represented in this process. Because even if they were by the governor or his appointee or his proxy, they'd still be overrode by New York and Jersey and in the process. So I think what should be alarming, and I know for those that wear their protester badges on their sleeves, it won't be, but I think every elected official should be concerned, as you've mentioned in your testimony, that Pennsylvanians are being impacted in this way by people who are not citizens of our state.
I fully agree, Mr. Chairman.
Thank you for your time today, sir. We
Thank you.
appreciate you sharing with us. Our next presenter will be Mr. Ned Lang, Vice President of the Pennsylvania Septic Management Association. Thank you for joining us, sir. And we do have, for the members in your information, we do have a letter from the Pennsylvania State Grange that they've submitted also for your reading pleasure, either now or later. And you can begin when ready, sir.
Thank you, Representative Metcalf. Good morning. My name is Ned Lang. I am the Vice President of the Pennsylvania Septic Management Association. The comments that I'm going to be putting forth today before you are those that were written and written by our lobbyist, Vince Phillips, and approved by our Executive Committee yesterday on a teleconference. And so I will present them to you and answer any questions you have at the best of my ability. So I respectfully ask that you support legislation that clarifies the role of the Delaware River Basin Commission as it relates to protecting waters in the Delaware River Basin region. Regrettably, the DRBC appears to be disregarding terms of the Interstate Compact by overruling the authority of the Pennsylvania Department of Environmental Protection when it comes to the proposed regulation that would permanently ban hydraulic fracking in the Delaware River Basin. This action by the DRBC is a classic example of what is called mission creep. Our proposed legislation is a measure to prevent a further expansion of that self-assumed authority, mission creep, by the UDRBC. It is foreseen that the Delaware River Basin Commission will likely attempt to regulate installation and maintenance of on-lot septic systems. These systems are regulated by the DEP under the authority of Act 537. The technology used to install an on-lot septic system must be approved by the department per Act 26 of 2017. A permit is issued by DEP to approve the construction. Compliance with these rules is also governed by DEP along with the help of sewers enforcement officers, local officials, or contractors whose activities are regulated by Act 537 and the DEP. This fear that Act 537 and the Department of Environmental Protection's regulatory authority will be ignored by the Delaware River Basin Commission is real, and as such necessitates legislative safeguardings. The Pennsylvania Septic Management Association appreciates the fact that the House Environmental Resources and Energy Committee is holding this informational meeting on the Delaware River Basin Commission. The Pennsylvania Septic Management Association represents firms that install and service on-lot septic systems and also performs other services such as applications of biosolids to farms. In addition, many of our member firms serve municipal facilities that discharge into the Delaware River and its tributaries. Our members have both professional and personal interest in conserving natural resources and the quality of Pennsylvania's waters. Many of our members live in the Delaware River Basin, as do I, and are themselves outdoors people who like to hunt, fish, hike, boat, and otherwise appreciate a quality outdoors environment. However, PSMA believes that the Delaware River Basin Commission has exceeded its authorities beyond its original mission in trying to keep waters pure and unpolluted. This is not just about fracking. Thus far, attention has focused on the anti-fracking regulation that the Delaware River Basin Commission is going to approve. Not surprisingly, fracking foes regard the regulation as a critical issue. Not surprisingly, supporters of natural gas development feel just as strongly on the other side. House members may recall the debate on House Resolution 515, put forth by Representative Fritz, which we thank you for, which ended up being a debate between pro and anti-fracking regulators rather than a debate on who regulates it. The issue is far larger than natural gas development and fracking. PSMA asked that the committee examine the larger picture, one of state sovereignty. Whether or not a lawmaker supports fracking, the fact is that there is a Pennsylvania law, Act 13, which regulates natural gas development. PSMA's issue with the regulation, the natural gas development regulation, is that an example of where the Delaware River Basin Commission decides that it can do what it wants, even if it conflicts with Pennsylvania law. We do not believe the Commission should be able to ignore enacted Pennsylvania legislation. This is purely a matter of state sovereignty. The original enabled legislation which entered Pennsylvania into the Delaware River Basin Commission is Act 268 of 1961. Section 7.4 Water Management reads, Section 7.4 Cooperative Planning and Operation, A. The Commission shall cooperate with the appropriate agencies of the signatory parties and with other public and private agencies in the planning and effectuation of a coordinated program of facilities and projects authorized by this article. B. The Commission shall not operate any such project or facility unless it is first found and determined that no other suitable unit or agency is available to operate the same under reasonable conditions. Ignoring Pennsylvania's Act 13 simply because the Delaware River Basin Commission is anti-fracking does not show willingness to cooperate with other public and private agency if one includes the Pennsylvania General Assembly or the Department of Environmental Protection as interested parties. In addition, B says that the Commission cannot act on a project. Let me say that again. The Commission cannot act on a project unless no other suitable unit or agency is available. The Delaware River Basin Commission is asserting that banning fracking is a project, something which is being litigated as we speak. The Pennsylvania Department of Environmental Protection and the Environmental Quality Board are quite suitable, and should the General Assembly change Act 13, DEP will implement those changes. Future Commission precedent expansion concerns. As an expansion of the Delaware River Basin Commission's power, the anti-fracking regulation establishes a precedent. In the name of protecting water, the Commission could now do these following things. Restrict or prohibit application of biosolids on farmland, even though normal activities of farming, which include application of these treated products, are regulated by the Pennsylvania's Right to Farm Act and by ACRE. This activity is also performed through a regulated permitting process, one which my company does every day. Restrict or ban installation of on-lot septic systems. These systems are a natural way to dispose of human waste, and installation is also a regulated process by Pennsylvania's Act 537, which gives DEP regulatory authority over septic systems and local officials. And sewer enforcement officers also have legal authority to review local projects. And let me just point out that I believe 47% of Pennsylvanians' households' wastes are treated by on-lot septic systems. It's a large majority, or it's not a majority, but it's a large number of people. The Pennsylvania Septic Management Association strongly supports House Bill 29, sponsored by Representative Jonathan Fritz, and we thank you. It limits Delaware River Basin Commission's authority to regulate on-lot septic systems. There is a precedent here. When the General Assembly first signed on to the Interstate Compact in 1961, it specifically carved out riparian buffers as outside the purview of the Commission. House Bill 29 would simply do the same for regulation of on-lot septic systems and make sure that DEP continues as a regulatory agency under Act 537. There's a recent Pennsylvania law that could also be undercut by the Delaware River Basin Commission. It is Act 26 of 2017. Currently, DEP is implementing Act 26 of 2017. This sets standards for approval of what are termed alternate systems. These are newer ways to install septic systems that are used in other states, proven technologies. Pennsylvania law specifies that the Department of Environmental Protection, working in conjunction with the Sewerage Advisory Committee, shall develop standards by which to review these technologies. The Delaware River Basin Commission should not be able to take away Pennsylvania's authority to decide which alternative systems are acceptable simply because it decides to. The PSMA asked that members of the House Environmental Resource and Energy Committee support Representative Jonathan Fritz's bill to prohibit the Delaware River Basin Commission from regulating or restricting installation and maintenance of on-lot septic systems, since Pennsylvania already has a regulatory system in place. Representative Fritz's bill would prevent the mission creep now taking place by the Commission, the DRBC, from expanding into the regulation of on-lot septic systems. And here's our conclusion. The PSMA hopes that a takeaway from this informational meeting will be that you understand the real and present danger to state regulatory, to legislative regulatory authority that the Delaware River Basin Commission poses. Members of the Pennsylvania Septic Management Association are businesses regulated under the laws of the Commonwealth, and we would like to keep it that way. That's my conclusion.
Thank you, sir. Representative Vitale.
I may have missed this at the beginning of your testimony, but you're not a Pennsylvania resident, is that correct?
I own a farm in Pennsylvania, and I grew up in Pennsylvania. I live right across the river in Narrowsburg, New York.
You're a New York resident?
Yeah, yes.
Okay. Let me just read you what Steve Tambini from the Delaware River Basin Commission said, and maybe you can respond to it. He, meaning you, seems to want to shield on-site septic systems from DRBC intervention. We really have no role in on-site septic systems. That's a local or PADEP issue. We are not sure why he keeps coming up from him. In fact, somehow he got Rep. Fritz to introduce legislation on this matter, a solution without a problem. So they're saying it's just not, they have no role in the regulation of septic systems, but you keep bringing it up, and we're introducing legislation to that effect, which is a solution in search of a problem. Do you have any comment to that?
Sure do, yes. Let me give you a little background about me. I'm a licensed master plumber. I own 10 Roto-Rooter franchises in 3 different states. We operate 2 different counties in Pennsylvania. We perform septic system services and a lot of plumbing services. Our customers, we install a lot of on-lot septic systems and do repairs to them. Our customers, they're commercial customers, when they renew their permit in Equinox and Lookout, a couple of them that come to mind immediately, in their permit application, there is now a spot, if you will, that requires either a permit from the Pennsylvania DEP or the DRBC. So you have to get one from the other. Now, we're not sure what the DRBC permit would include, but I have given that to Representative Fritz about a year and a half ago, and it is actually taking place. This mission creep is definitely taking place, and we're concerned.
So why are they saying they have no role in on-site septic systems? Have you applied? Have you ever applied to them for a septic with regard to septic systems?
It's a permit that the customer has to get. It's not the company.
Are you aware of any customer who's ever had to interact with the Delaware River Basin Commission on these permits?
Yes, it's in their permit application.
But have they actually? You said it was an either or.
Right. So
have they chosen the or?
This customer applied to the DEP, but they were also asked to check with the DRBC. And just on another issue, we also haul a lot of biosolids and do a lot of land application throughout Pennsylvania and New York. And in some of they have an impact fee now, the DRBC. So a few of our wastewater treatment plants, when they want to update their permit, some of them have a $50,000, $60,000, $70,000 bill from the DRBC to just simply duplicate what either the New York State DEP is doing or the Pennsylvania DEP is doing as far as their permit review and then promulgating a new permit. But they're actually paying an impact fee to the DRBC now, on top of all the other costs, to the local regulatory, the state-based regulatory agency.
Okay.
Thank you, Representative Vitale. Representative Fritz.
Thank you, Mr. Lang, for being here today. Appreciate you taking the time to travel down.
My pleasure.
So we have a construction project or a septic project. We have EPA restrictions or regulations. We have DEP, plus we have county planning. Can you specify how all those agencies work together right now to regulate and oversee construction of on-lot septic systems?
Yes, absolutely. You know, basically, we work with our local SEOs, sewer enforcement officers in Pennsylvania. Unless the system is larger than what they can oversee, then we work directly with the local DEP representatives from that region, okay? So it's a very, you know, it's an extensive process. You know, there's a lot of formal work that has to be done before you can install an on-lot septic system as far as your perk tests, soil tests. Then you have an application fee to the local SEO. He approves it, and then you also have the process where you have someone design the system for you, and then of course there's the installation of system, all which are heavily regulated, overseen very, very well by both all the different levels of government, from your local municipalities to your state DEP. So it's very heavily regulated. It works very well. The PSMA is really pushing for expanding the type of alternative systems and technologies that are available outside of Pennsylvania to our residents and customers in Pennsylvania, which are proven technologies that are a little bit outside the box, if you will, from what is now allowed. So yes, you have a very extensive, good, coordinated regulatory process in Pennsylvania that works as of right now, outside of the DRBC.
In order to satisfy Representative Vitale's curiosity, would you be able to provide us with a document or an application that does cite DRBC and their involvement with septic system installation?
Absolutely, yes. I have it back in my office.
Okay, thank you.
Thank you, Representative Fritz. Any other members?
Can I make one more comment?
Yes, sir.
Speaking to the representative, I'm sorry, Isaacson. When you were talking before about the Constitution.
You could just talk into your mic, sir.
Okay. I have to look over here. I'm going to scoot over a little bit. As you were talking before about the constitutional rights of people in the lower river basin, Delaware River Basin, versus the rights, if you will, in the upper Delaware River Basin, are you aware of the Old Barnes landfill, which is pouring pollutants into the Delaware River on a daily basis? You can go to Barnes Landfill Leachate. I was there. My company used to work for the DEC, and they ran out of money in around 1996, 1998, and they stopped us from hauling out the leachate. There's tests now done by the Upper Delaware River Council that shows that there's high barium levels and 7 other carcinogenic pollutants now entering the river below the Berryville Bridge every day of the week. And you can go, and when you have a large rain event, the leachate tanks then at the bottom of the landfill spew out a large amount of leachate from an old landfill started in 1950-something. So you know all the different pollutants that are potentially there and are definitely entering and impacting the water quality of everybody downstream from Berryville, New York.
Thank you.
Thank you very much for saying that. My thought on that is we don't want to repeat the history in the past, and we want to learn from it as we move forward.
Fair enough.
Thank you, Representative Isaacson. I think the point being made is that New York currently is dumping carcinogens into the river, and they're not cleaning up their act, while their same representative is shutting down our ability to move forward with proven technologies that are safe to utilize in the basin. So I think the hypocrisy shouts from the rooftops, and it should for Pennsylvania citizens, that New York needs to clean up its own act. I mean, they're shutting down access to the Northeast for having a pipeline run through and bring gas. So we end up having Russian gas delivered off the coast to Massachusetts, I believe it was, because they can't get Pennsylvania gas. They're dumping their own pollutants into the river that comes down to our citizens at the same time as working to utilize their political muscle on the commission. They shut down drilling for our citizens that would result in more jobs, more royalties, more wealth created for Pennsylvania citizens, and better quality of life for everyone in the community. somebody tapped me on the arm. Was there another member that wanted to, Representative Dush?
And I'll just dovetail with that. You had mentioned earlier about your your people being folks who are like with Trout Unlimited, that kind of thing. They care about the quality of the water, and I think my landowners, I know my landowners do, and I think Representative Fritz's landowners as well care very much about that. In our areas, the water is good. It is clear. We try our best to maintain it that way. It's more when you get down into the lower Delaware River where you start seeing more of those pollutants actually getting into the system. And I think when most of the complaints about us are coming from places where there is a huge problem with pollution versus those of us who have people who are drilling responsibly and maintaining the environment and have clean streams, people can canoe, kayak. I think it's very disingenuous, and I thank you for your testimony.
You're welcome. And I live alongside the Delaware River in Narrowsburg, right on the border. I look into Pennsylvania, and there's a train track that comes up. There's a train track in front of my house. And through the years, I've been, I was born in 1960. I've lived there all my life, except for the time I was in the service. And recently, we just had a derailment up by Hancock. And so the potential for pollution, if you will, to the river basin is so much more exacerbated by that type of activity than apparently what natural gas development would ever offer to the basin with the knowledge of what we've learned in the Susquehanna River Basin and how their quality of water has actually improved with extensive natural gas exploration.
Thank you, Mr. Lang, for your time today. We appreciate you joining us and making the trip in.
Thank you very much.
Thank you. That concludes the presenters for today's meeting. We'll look forward to a vigorous debate next week on the legislation that we'll be noticing probably here shortly later today or tomorrow. Thank you to the members for your time. Thank you, Representative Mao, for joining us. Representative Reese had been in the audience for a while. Motion to adjourn by Representative Fritz, seconded by Representative Sankey. This meeting's adjourned. Everyone have a great day.
1 2 1 2 1 2 3 4. Feedback. 1 2 1 2 1 2 3 4. And also if the level is fairly constant or consistent. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1. Yep. Okay. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. Okay, sounds a little hotter in here. Okay. 17. Okay. Okay. Is it ringing any? Okay. One two one two 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4. 1 2 1 2. 1 2 1 2 1 2 3 4. 1 2 1 2 1 2 3 4.
That's the only, they're gonna do some re-referrals, and that's it. Re-referral. Send that bill to, is this an 800 series? Is there like, I'm wondering what bill, what's Sue's bill number? Uh-huh. Okay.
Oh, okay, great.
Good afternoon. I'd like to call this meeting of the House Local Government Committee to order. I'm Chairman Dan Mal. My Vice Chair, Bob Freeman, welcome you.
Democratic chair, that's okay.
Or Democratic chair, what am I thinking? We're such good friends that I just,
It makes it when you
just-
take it.
yeah, it sure does. We've got 2 bills to re-refer today and 1 to vote on, but before we do anything, we need to take the roll. Ashton, would you please do so?
Chairman Mao,
Here.
Representative Brooks,
On leave.
Frank. Here. Gregory,
Here.
Irvin,
Here.
James,
Present.
Maloney,
Here.
Miller,
Here.
Nisworski, present, Rader, Rigby,
Here.
Schmidt, Thomas, present, Wentling,
Here.
Wheelan,
Here.
Minority Chair Freeman,
Here.
Parisi,
Here.
Hanford,
Here.
Hill Evans,
Here.
Kim, here, Lee, here, Malagari,
Here.
Mirsky,
Here.
Sanchez,
Here.
Sappy. Here.
Thank you, Ashton. I'd like to open this meeting by re-referring House Bill 403 and House Bill 645. I need a motion and a second to re-refer the bills.
Mention the committees are going to.
House Bill 403 will be going to Consumer Affairs, and House Bill 465 will be going to Urban Affairs.
And second.
Bill Evans in for.
Okay. Rob, do you need to make any more comments?
Nope.
Okay. Any questions from the members? Are there any negative votes? Seeing none, hearing none, these bills will be re-referred. And the first bill for a vote before the committee is House Bill 103, introduced by Representative Maloney. I'd like to have a motion and a second to call up the bill.
Representative Maloney and Representative Irvin.
Maloney and Irvin. Rob, if you'll explain the bill.
Yes, House Bill 103 is a bill the committee looked at last session. This amends the municipal planning code to create procedures for subdivision and land development of non-building lots. Currently, there is no uniform standard for the creation of one. DEP does have a form that property owners can fill out when creating them. This legislation will require townships to amend their zoning ordinance to allow for the creation of these non-building lots when presented with a completed DEP waiver form. The bill allows for the creation of 2 non-building lots per an approved waiver if you're a developer. If you are splitting the land amongst family members, you can create I'll use the example, if you have 50 acres, you can do 5 10-acre lots of non-building on a single application, but that's only if you're splitting it amongst immediate family members, which is defined in the legislation to mean spouse, parent, child, grandchild, brother, or sister. So, and we also define non-building as a lot that does not contain any structure that generates sewage. As part of this, once a non-building lot is created, if you ever go to develop it in the future, at that time, the land must comply with any regulations, perk tests, DEPs that exist at the time that they go to develop it. So if it's 20 years down the line, whatever the standard is in 20 years, that's the standard the property owner will have to develop according to.
Thank you, Rob. Representative Maloney, do you have any comments on your bill?
Thank you, Mr. Chairman. Thank you for bringing this up. I believe Rob did a very good job with this. It's really pretty straightforward. There's a provision that already does allow for this through the DEP waiver. It's just that there can be a problem with certain, and I would tell you that I experienced it firsthand, on who will accept or allow and why they would not accept or allow this makes no sense. So we just want to make sure that the people have that right to be able to proceed, especially in estates and in family matters. So thank you, Mr. Chairman.
Thank you, Representative Maloney. Chairman Freeman.
Thank you, Mr. Chairman. As Rob mentioned, this was a bill that we took up last session, and Representative Maloney was very gracious in retaining the language which the committee had inserted last session, which I think made for a better bill, more defined bill. and really clearly outlined the process involved in this proposal. So my thanks for him for reincorporating that. Last session, the initial bill met with some resistance from PSATs, the Pennsylvania State Association of Township Supervisors, but once the amendatory language went in, they were fine with it. So we haven't heard from them, but I assume they're still fine since they supported this last time. DEP did raise concerns last time and also this time, but they have yet to clarify any real deep concerns. I think that's fair to say. So there may be some effort after they review it to maybe suggest some amendments on their part, which we'll share with the prime sponsor and see where we go from there. But as it stands now, I think we have a piece of legislation that was refined nicely last session, and so I'll be supporting it.
Thank you, Mr. Chairman. Any other members have any other comments? Representative Miller.
Thank you, Mr. Chairman, and this may be for the maker of the bill or someone else, but in terms of the bill allowing for the creation of 2 non-building lots, and if you're a developer, but up to as many for family members, my question is there any provision in the bill that would prevent the subdivision to, say, 5 family members, and then they turn around and sell it before there's any building that occurred? Should there be, if it's designed to be unlimited for families, should there be a limitation on this that would say that a subdivision must remain in retention of ownership for 5, 10 years or what have you?
No, I think I can answer that for, I think what you're asking is that, and so let me just explain the functionality. So if you decided to subdivide this for each one of your children, and you provided a non-building waiver declaration, which has all been filled out, whoever takes ownership of this lot takes ownership of those provisions. And so anything that were to be done, regardless of who owns it, would follow the standards and regulatory process from there on.
Can I follow up? My question then is why the distinction between a family member and a developer then?
Because there has been issues, which I can speak to very personally, where families would like to subdivide an estate and keep some historic and some tradition for family members, and then they can make that decision later. Like if your child was 18 years old and not ready to do anything and it's in their life with respect to the land, they could have ownership of that, and then if they decided that they had to sell it and move on, then they could do that, but then the new owner would have to do it, take care of any regulations from there on. And so that's why if you have 6 children, you have 6 lots if you can make them. If you have 8 children or 2 children, you can do it that way.
My concern, and we supported this in the last time, and I'll do so again. I just hadn't really contemplated this in terms of the fact there could be a quid pro quo or some developer make an agreement with people who might be able to just get 2 lots, but now makes an agreement with a family to get 5 or 6 for a purchase of sale at a later time. So I'm just wondering if maybe we can talk later about a possible amendment.
Well, I would tell you right now that there's no issue with that, because it doesn't matter who takes ownership of that piece of property. They would have to follow the regulatory process as if they were purchasing it out in the open market.
Then if a follow-up, then why would there be a prohibition for 2 lots for a developer?
If I remember correctly from last session when we sat down and discussed this bill, there was concerns about developers potentially exploiting the system by, splitting off properties, having 16 subdivision, getting through the process without actually truly declaring what they're doing. They split everything off into non-building lots and then one at a time, slowly bring them back on the system instead of, going through the full zoning. There were some concerns about them exploiting the process by allowing them to infinitely subdivide property in a non-building fashion.
Right, and furthermore, if I might, there was some issues where lots would be basically non-conforming, and so that if they could get the subdivision along, they could create them as non-building lots and then deal with it later.
Any other comments? Yes.
Thank you, Mr. Chairman. I have a question. Will local governments need to pass ordinances to come into compliance with this? And then my other question is this a widespread problem? My experience in local government, I've not, had this situation come up, and I'm just wondering if we're over-legislating a situation that doesn't happen often.
I can speak to one half of your question is that, yes, they will have to pass a new ordinance. They'll have to actually just amend their existing subdivision land development ordinance to include a new provision allowing for the creation of non-building lots. That's the extent of the amendments ordinance they'll have to do. As for the prevalence of this problem, I can't speak to that. I don't know if the prime sponsor can.
All I can speak to is those who have, through this process, reached out to me and saying that they had certain issues in different places of the state where it was very inconsistent, which thus is why they come to the legislature to make that an even playing field.
Thank you. Does that answer your concerns? As someone who was a builder myself for 25 years, if I owned a piece of land and I wanted to split it up between my children, as long as it didn't go against the constitutionality of our rights, I would think that a township or borough standing in the way without good cause of me being able to give that to my children would upset me as well. I think that's more the crux of the issue as opposed to how often does it happen. We want to make sure that our rights aren't trampled on in the process. And if we can move something forward that protects our rights to hand land to our children, I think that's a good way for us to go. Mr. Chairman?
I think one of the safeguards to be kept in mind, too, was the language which the committee adopted last session, which Rob touched on briefly. If these parcels end up trying to develop, then they have to be in compliance with all the SALDO requirements of the municipality. And that's really the safety net in this proposal. You can subdivide if you're not going to build on it. As soon as you decide you want to build on it, then you have to be in compliance with all the SALDO requirements of the municipality. And that goes through the review process at the local level. As well as DEP, yeah.
This doesn't, if I'm correct me if I'm wrong here, this doesn't usurp the building ordinances.
Well, in a sense, it leapfrogs over the fact that normally if you subdivide, you'd have to go through all the requirements of SALDO as to the Sewage Facilities Act, I believe, which comes into play through DEP. But since Representative Maloney's legislation says you cannot build on it, that says, okay, so you're subdividing the land, you can subdivide ownership. But when you decide to build on it at a later date, then you have to be in compliance with all the SALDO requirements and all the DEP Sewage Facility Act requirements.
Correct. That's the point I'm making. It doesn't usurp those.
No, it just leapfrogs one step in the process as far as subdivision. But then as soon as you want to develop, you go right back to the subdivision requirements and the DEP requirements.
Correct. Thank you. Any other questions or comments? Are there any negative votes on the bill? Seeing and hearing none, the bill will pass unanimously. Thank you all so much. This voting meeting of the House Local Government Committee is adjourned.